Just a little introduction about myself for those of you who don't know me. I am a lawyer. I work now at a firm called Zwilgen. I'm the California office. The firm's based in Washington, D.C., and we do a bunch of internet law issues, privacy, copyright law, computer security, all sorts of stuff like that. I joined the firm in December of last year. And before that, I was Civil Liberties Director at the Electronic Frontier Foundation. And before that, I ran the Center for Internet and Society at Stanford Law School. So today I'm going to talk about the law of mobile hacking. And for those of you who've seen me talk in the past, you know I often will try to do a legal topic that kind of runs through the various laws that are out there that arguably apply to the kind of research that the people who come to this conference do, and sort of highlight for you some potential issues and problems that you guys might run into as practitioners in security. And what I'm going to try to do today is sort of narrow that down a little bit to talk specifically about the legal issues that have to deal with mobile hacking, since mobile's been so interesting in the past year and there's so much fun stuff going on there. There are a couple of things that make hacking mobile devices like phones and tablets and those sorts of things different from your regular kind of computer security research. So that's going to be what I'm going to focus on today. Now I'm going to go through this in a format where that looks good. I'm going to talk about these particular activities that are flashing up on the screen now, and I'm going to try to kind of take this topically, not by legal topic, because I don't think that that would make too much sense to you guys, but take it by kind of a research topic and sort of highlight the areas of law that might be relevant there. And then hopefully I will leave some time for questions as well. So if you have questions, you can raise your hand if you have questions as we go, and if I feel like it's a good time, I'll stop and ask you what your question is, and I'll repeat it so everybody can hear it, or hopefully we'll have some time for questions at the end. Okay. So I'm going to try to cover all of these issues today. I think that these are the things that people have been working on that have been really interesting. And in some of these cases, some of these types of issues, I've been an observer, and in some of these issues, I've actually been involved in trying to help people who face these particular legal issues. So first and foremost, with mobile hacking, you're thinking about things like the iPhone or like the iPad or something like that. In order to really get a sense of what you can do with a device like this, you might want to install code on it. And as you guys all know, iPhones and iPads and some other devices are locked, meaning you cannot install code of your own choosing on the device. So that's often the first step. You want to unlock it, you want to put code on it, you want to test it, you want to see what it can do. Well, there are a couple of legal reasons why installing code on one of these devices is a no-no. I was at Dino's talk yesterday where he was talking about hacking the iPhone, and the whole time he was talking, I was just thinking, oh, that's illegal. Yep, that's wrong. So, sort of a caveat for those of you who are risk adverse, and I doubt that that's probably anyone in this room. But, when I say that something is illegal or arguably illegal, I'm not saying you're going to get in trouble for it, or that there's not a right way to do it, or that, it's wrong. I'm just saying there's some sort of potential legal risk associated with it. And, you guys as practitioners, when you're doing some kind of research, need to make an assessment about what the severity of that legal risk is. In some cases, your attacker is the government and the criminal law. In other cases, the party that's really going to be your enemy and try to stop you from either doing what you're doing or talking about what you're doing will be the company whose products you're researching and who might be affected by any disclosures you'd subsequently make. So the locked devices have a couple of things that the company, let's say Apple in this case, put into place in order to try to regulate or control what people will do with them. Number one is the license. So when you are a software developer, or when you use one of these phones, you have a EULA that you click through and you agree to the terms. Then there's also technological restrictions. The phone is locked so that technologically it checks to see if the code that you're seeking to run has been properly signed and approved by Apple, and if not, it won't run it. And those technological restrictions with regards to the iPhone and with regards to certain other kinds of computers and devices are backed up with the force of law. by the anti-circumvention provisions of the Digital Millennium Copyright Act, and those provisions are pretty complicated and strange with a few little safety hatches, which we will talk about. So first, the EULA. EULA is essentially a contract. Contract's an agreement between two people or two entities, and in the olden days, I think we're thinking about handshake between two people. For real estate contracts, you would take a clump of the land and hand it over to the other guy. No, we have none of that anymore. Now you have the 100-screen EULA with language that nobody reads or can possibly understand, and you have to check the box and click I agree as fast as possible so you can get back to doing whatever it is that you wanted to do, playing Angry Birds or whatever it might be. But buried in these EULAs are terms that restrict what people can do with these devices, what security researchers can do with these devices, the primary one being a no reverse engineering, no disassembling term. And many, many pieces of software have this type of EULA. You click I agree. What does that mean? From a legal standpoint, we think a lot about these contracts in terms of their enforceability and what's going to happen if you breach them. So if you reverse engineer an iPhone and it's in violation of the contract, really there's two ways that you can look at it, right? So the easy way, the soft way is you breached a contract. And in the world of the law, a contract is this promise, but people break promises, these things happen. It's meant to regularize economics, regularize commercial interaction. There's really, at common law way back in the day, there wasn't any stigma associated with breaking a contract. Really all it meant was that you had to make it up to the other person by paying them financially whatever it was that they ended up losing on the deal as a result of your not, keeping your word. Well, things have come a long way since then, and there's all sorts of other glosses now on the contract law where you can get injunctions, you can get not so much, you're still not supposed to be able to get punitive damages, but one of the more severe issues now for EULAs and breaking EULAs is not from copyright law or from the source of copyright law, but looking at the software, the EULA as part of software licensing and integrating the idea of the EULA and its restrictions into the concept of copyright. Okay, so for copyright, original works which are fixed in a tangible medium are copyrighted. And they're copyrighted automatically in the United States upon fixation. And that means that the creator has certain rights with regards to that piece of work, including the right to control derivative uses, the right to control copies, the right to control derivative uses. And one of the ways that software companies have been pushing the EULA issue is not just a contract, you break it, if we lost money on it, you pay us, and if we didn't, then there's no ramifications, you can basically do whatever you want, but have pushed it as saying the EULA is basically part of our agreement to let you use our copyright. And if you break the EULA, then you don't have any right to use our copyright. And if you don't have any right to use our copyright, then you're in the world of copyright infringement. And once you're in the world of copyright infringement, you're looking at statutory damages, you're looking at statutory damages per work infringed, and now we're talking about something that actually can be a rather heavy hammer, a rather strong enforcer of the EULA terms. Okay, and so I'm not going to get too much into this now. There's been a number of cases that have looked at this issue and are trying to sort of refine the situations under which when you break a EULA, it's just you breached a contract, and when you break a EULA and you violated the terms of the license and therefore you didn't have a right to use the copyright and therefore you're a copyright infringer, and all these other dark things can happen to you as a result. Okay, so the software EULAs can be very important. Another issue, probably one of the primary legal issues associated with jailbreaking phones or iPads, is the anti-circumvention provisions of the Digital Millennium Copyright Act. And I'm not going to read them to you here. You can read it yourself while I talk. But you'll see that there are essentially two provisions of the Act which are important. One is what I would call an acts restriction, and the other is a tools restriction, okay? So the acts restriction says you can't circumvent, get around, a technological measure that controls access to a copyrighted work, okay? note, and this is very important because this is something that's special about our United States law and that's important for our security research purposes, it doesn't say don't break DRM and then make unlawful copies. It says don't break DRM and then use the work in a way that we don't want you to use it. Don't access the work. So this is why you've seen this provision used for stuff like machines that don't pay attention to region coding on DVDs or something like that. There's nothing copyright infringing per se about that. It's just you're getting access to the work, and the work was protected by a technological measure. Okay? Now, the second part of the statute is a restriction on tools. And these are, basically software tools or whatever that would enable somebody to get access to a copyrighted work. Because maybe you guys are going to, just break DRM and be able to access the work, and you can jailbreak your phone and everything. But for the vast, unwashed majority of us out there, we need somebody else to give us the jailbreak me tool or to give us DCSS or something like that so that we can do the, so that we can do the decryption, do the access ourselves. Well, the statute has a prohibition on the distribution of tools. So you're not allowed to distribute these tools either. There are very narrow provisions under this law for security research and for reverse engineering. In previous talks that I've given, I've kind of gone through the details of those and sort of explained the ways in which they sort of fall down in the face of how people really want to do security research. You're not always doing the research for the company who's the promulgator of the DRM or that sort of thing. But I'm not going to go back through those now, although if people have questions about them later, I'm happy to answer them. But I do want to talk specifically about in the mobile context. And in the mobile context, there is a provision in the anti-circumvention law that allows every 3 years for a rulemaking before the Copyright Office. And this is supposed to be kind of a safety valve for where there are situations where this provision of the DMCA, 1201, interferes with legitimate user activity. The Copyright Office can issue rules that sort of alleviate that problem. And in 2006, when I was at Stanford, I saw it, and we won a rule from the Copyright Office saying that it would be okay to unlock phones so that they could operate on different networks. So if your phone was like locked to a particular network and you resold it to somebody else and they didn't want to have T-Mobile or whatever it was, you could unlock the phone and use it on a different network. In 2009, while I was at EFF sought two mobile device rules. One was for, again, the unlocking of the phone so that it could work on other networks, and the second was for jailbreaking. Basically, at that point, just thinking about jailbreaking the iPhone and saying, people want to jailbreak this device so that they can run programs of their own volition on it. It has nothing to do with copyright infringement. It should be allowed. And Apple fought it, but eventually the Copyright Office did issue that rule, and it says that there's an exception under 1201. 1201 doesn't apply for computer programs, for use of the computer programs that enable wireless telephone handsets to execute software applications where the circumvention is for the sole purpose of enabling interoperability, where the applications have been lawfully obtained, and it's going to be, and the handset's lawfully obtained, where everything is lawfully obtained. Okay, so that's really interesting because that was back in 2009 when we applied for it. It's now 2011. Notice there's no mention of the other great platform to jailbreak, which is the iPad. iPad didn't exist back then when we applied for this exemption. So here you have in this 3-year period this device that's out there that people want to jailbreak and experiment with, but it's not included under the exemption, and if the jailbreaking doesn't fall in under one of the other exceptions, then it violates Section 1201. So you see here, I think, one of the real limitations of the Copyright Office every 3-year rulemaking, just for example. So I think 1201 is a real serious legal obstacle to certain kinds of security research with the iPhone or the iPad. What we haven't seen, and this goes to what I was saying before about your risk analysis, what we haven't seen is efforts by Apple to enforce it. And then the other thing I want to mention about this that I failed to mention before, when talking about the limitations of the rulemaking allows exceptions for acts of circumvention. So basically it says you can circumvent for the purpose that you see here. What it does not include is exceptions for tools. So that means that even after the rulemaking issues, it is still, if it was unlawful to jailbreak the iPhone under the Section 1201, it is still unlawful after the rulemaking to distribute tools to jailbreak the iPhone. So this is a severe limitation in the entirety of the rulemaking idea, that you would have exceptions that go to acts, but not exceptions that go to tools that enable people to actually accomplish those acts. It's like a freedom that's dependent on a crime. So, it's not what I would call good legislative activity. Okay. What else is interesting? What else is interesting that people are doing? Yeah, question.
Can you define what a phone is? Because you're talking about an iPad, which has 3G in it, which we can put, VoIP and turn it into a telephone. Similarly, any PC in here can do the same functions as well.
Yeah, so the question is, what's a telephone? When they ask you a rule that says telephone, it has 3G, it has Skype, it can be the same functionality, what's the definition? I think so. So the answer is no, I can't define that. I think the question it would be a question under the law, and the way that lawyers would look at this is we would look to other statutes that use the word telephone and other court rulings or other provisions that use the word telephone and try to make an assessment of what it means under similar statutes. And then also then what we would do is look to the underlying record in the Copyright Office rulemaking to see what was discussed, so what the Copyright Office intended at the time that they issued the rule. And I think that, I don't want to say that it's limited, but I think there's a strong argument that when you say wireless telephone handsets, you are talking about, you're talking about your traditional cell phone that operates over the cell phone network. I know that under other statutes, for oral over-the-air communications like with Skype or that sort of thing, that some of these are considered to be packet-based communications and thus more like email, and treated more like email than they are treated like phone calls. So it's a big debate, for example, and we'll talk about this a little bit later, under the Telephone Consumer Protection Act, about SMS messages, commercial SMS messages. Are commercial SMS messages emails that are governed by the Can-Spam Act and those limitations on commercial solicitation, or are they phone calls governed by the TCPA and governed by those rules, to limit commercial solicitation? So it's a great question, but the short answer to your question, can I define it, is no. My long answer, I think, explains what the complexities of it are. Yeah, well, I think what needs to be done here is the rulemaking is every 3 years. So 2012 is coming up. We have EFF lawyers here in the audience, and I'm sure that they are eagerly preparing already to seek to renew both of these exceptions in light of the new technology. So they're going to be calling you for for what the expanded definition of the device and the software program should be, so that we can enable this functionality sort of separately. I think your question just raises another thing that's so interesting about practicing in this area of the law is, what does the law regulate? Does the law regulate technology? Does it regulate functionality? What matters most, here when what you're looking for. So, okay. So studying malware. Malware, particularly on the Android platform, has been really interesting. How, if you wanted to do an analysis of malware on the platform, would you do it? There's also EULA issues associated with using the marketplace or other kinds of software outlets. And licenses for each of the individual applications that you might download might also have a no reverse engineering term. Now, I'm not particularly concerned that a malware distributor is going to sue my clients for violating their EULA, right? I mean, this is one of those things. Yes, maybe there's an argument, but that doesn't sound like a great court case to me. If I were the plaintiff's lawyer, I certainly wouldn't take it. But you do want to be careful whenever you have any kind of larger entity that has a no reverse engineering term, if you're going to do mass downloads of applications and do some kind of analysis on it that violates the EULA, you got to kind of pay attention. So I mentioned EULAs briefly before, but I think this is just a chance to focus a little bit more on the issues associated with doing research on software that is protected by the EULA. So, a couple of things you can maybe creatively do. Think about how you could get a copy of the software that you're going to study that is both non-infringing and not subject to the EULA. Right? How could you do that? And I think, eBay is one of the great sources for this type of stuff. If you're going to have software that's already installed, you don't click through on the EULA, you're not a party to the contract. If the person who's the seller is transferring to you all of their copies, then it's non-infringing. So you're in a good position with regards to both contract law and copyright law. Other sorts of things that we tend to advise our clients who are doing security research, particularly if they're researching a product that's issued by a company that is known to be rather litigious. You want to make sure not only that you're not, try at least, not only not to violate the EULA or copyright law and you get your original version of the program, but also at the end of the time when you're done with your research, destroy the copies of the program that you have, and then clean room whatever stuff you eventually code yourself to make sure that the team that did the reverse engineering and the research is separate from the team that does the coding, so that there's a very strong argument that nothing of the original code that was produced by the other party is going to be included in your final product. Okay, because then that's potentially a derivative work, potential copyright infringement, and that looks bad. Now sometimes because code's functional and not necessarily, not all code is beautiful and original. If you're coding something for a particular functionality, it's going to look a hell of a lot like, or maybe even exactly the same as, the original code that did something. But if you've clean roomed it, then you can say, hey, look, we had a process in place whereby, these teams were separate, so any copying that happened was just inadvertent and a pure product of functionality as opposed to actual copying. So there's a question over here. Yes, sir. So if you're going to do some screening on your own app store, I think that's really nice for the users, and you will probably instantiate that in your terms with the people who provide software to your app store, so that they know that you're going to be doing testing on it and reverse engineering, and they agree to allow that in exchange for putting the stuff up. If you look at Apple's developer agreement for, if you can get a copy of it, and then you can look at Apple's developer agreement for people who put apps up on the App Store. It's actually a pretty fascinating document, the stuff that they make their partners agree to. Okay, so base station spoofing. This is just a little highlight of some of the legal behind the scenes that went on with Chris Padgett's IMSI Catcher presentation from last year, and I worked on talking through some of these legal issues with Marcia Hoffman from the EFF, who's right over there. And this was just, from my perspective, one of the most complicated security researcher advising stints that I have done, because it involved FCC regulations. And I don't know if any of you, I know Bob's done this, but I don't know if anybody else in here has ever taken a look at the FCC regulations. But, I don't think that I'm shaming myself too much by admitting, I don't understand those. They're really complicated, and there's a lot of them. And they're pretty technical. And so, if you're doing a certain kind of research where you're going to basically pretend you're some part of the telephone network, the FCC regulates that really comprehensively. And it's super cool and fun to try to do it, but the question of whether you're running afoul of something is pretty high. And, the FCC cares about this stuff quite a bit. So there are certain frequencies that are licensed for public use and certain ones that are off limits, and you're not allowed to broadcast or do anything on those frequencies. And if you do, then the FCC will call you and yell at you. And not only do they call and yell at you, but they don't tell you whether they're going to actually do anything about it or not. They just raise a bunch of questions, tell you that you're probably in violation of their law, grumble a lot, and say, we'll just see what happens. So that's not very reassuring. So basically, if you're going to build one of these things, or you want to do some testing about how GSM works or how cell phone networks work, and you want to set up your own kind of spoofing device that acts like a cell network, and you want to see what happens when other people's phones or even your own phones connect to it and what you're able to do with it, the first thing you're going to end up with is a problem or a potential problem with FCC regulations. Now, in order to sort of figure out what a good attack would be with one of these IMSI catchers, basically what you want to do is see, is it possible for me to set up something where phones will connect to it, they think they're getting normal cellular service, and you can pass calls back and forth and man in the middle them. It's basically what the experiment is. Other than the FCC, though, there are a lot of stakeholders who could be pissed off by this type of project. Other than the FCC, who would be mad? Well, AT&T. Right? If I am an AT&T customer and my phone connects to a fake AT&T base station and I think I'm on AT&T's network, number one, AT&T is mad that they're getting impersonated. Number two, if my phone service suddenly sucks, who am I going to blame? Well, maybe my phone service is suddenly better. I don't know, because AT&T's phone service sucks so badly. It's like, oh, look, my calls are actually routing. This is awesome. I wish I could be on Padgett's IMSI catcher all the time. But the AT&T is not going to like that for trademark reasons, for customer service reasons, for all those reasons. So you've got some potential issues there. And the next problem is if you're doing a test for man-in-the-middling the phones, there's a law. It's the Wiretap Act. And the Wiretap Act says you may not intercept the content of communications. And so, there's an exception to the wiretap law, which is for consent. Consent is okay. So if I want to do a controlled experiment with my own phones and people who are, basically on my team, and we're going to do a test or something like that, everybody agrees, everybody understands we're going to see if it works. And I can call, if I'm part of the team, I can call my mom, who's over there in the audio booth, and I can, say, hey, Mom, this is going to be intercepted. We're doing an experiment. And she'll say, what? And I'll be like, okay. So it's fine because it's consent. But one of the ways that this thing works is it broadcasts a signal and says, here I am, I'm a base station. Phones will just connect to it. And if somebody's phone connects to it accidentally, well, then you're in danger of this wiretap issue, right? If somebody just connects to it accidentally and they're making a call, you're in danger of this. So how do you deal with this? Well, can you get consent from everybody? How do you go about doing that? You can put up signs, you can warn people, or can you block it so that people who are not wanting to be connected can, be excluded? Like build a giant Faraday cage and do the experiment inside the Faraday cage so that people outside the Faraday cage don't accidentally connect through the base station. So, it's getting progressively more expensive, not to mention the lawyer time, progressively more expensive to try to figure out how you're going to do this particular experiment. And then just to mention it, of course, there's also issues with regards to capturing transactional data. There's a federal statute there that doesn't let you capture transactional data either. So you need to be concerned about how to deal with that part as well. Okay. Super fun project. Okay, one of the talks here today was about hacking peripherals and the issues of embedded software, embedded devices, and all these things today that are now potentially controllable over the phone network. Security cameras, stuff inside your home. I often wish I had one of those things inside my house because I always forget and leave my heat on, and I would love to be able to shut that off. These things are all controllable over the phone network, which means that they're vulnerable to remote, to being, controlled remotely. So, what laws would control or potentially regulate the exploitation of security cameras or the heating system in your home or something like that? Well, there's the General Purpose Law that deals with unauthorized access to computers, which is the Computer Fraud and Abuse Act, close to my heart, one of my favorite statutes. And the Computer Fraud and Abuse Act prohibits unauthorized access or exceeding authorized access to computers, and usually thereby causing damage. There's a number of different kinds of damage, like if you endanger somebody's health or something like that, that also counts. And just purely doing it is bad, but it's a misdemeanor. But for the felony, which is what the feds really like to prosecute, you need to have some kind of damage. So my question, and I think this is an unanswered question, maybe we're going to see this more as time goes on, is if somebody hacks my security camera at home or something like that, is that a computer? So this kind of goes to the gentleman's question, like, what's a telephone? What's a computer, really? Well, the CFAA has a definition of computer, and this is the definition. Who thinks that a security camera that you can control remotely is a computer? Okay. Who does not? So a few people don't, but more people do. I don't think we really know exactly what a computer is, and I think the definition of computer is sort of evolving over time. I remember I had a case where my client was out on release pending his trial, and it was in a computer hacking case, and they didn't want him to use any computers because he was too dangerous. So they had probation had proposed a rule. Okay, he can be out, but he can't use any computers. And so we were like, what about an ATM? Is that a computer? What about, just sort of like going through, what about the microwave? What about the, And at that point, like trying to come up with a definition of computer that kind of got to what we all sort of knew was what probation was asking for without being overbroad and getting into these other things that also were basically computers was super hard. This is one of the, I don't know, not one of the funnest parts of the law for me, but anyway. And then the next question, I think, is whether there's going to be the requisite damage if you do some kind of control of these things. Damage is defined as any impairment to the integrity or availability of data, a program, a system, or information. I think certainly if you, sort of bring the security camera or whatever it is offline, that could cover that. But if not, if it's more just controlling it, or you're sort of also getting the feed from the camera, is this going to apply? And then the definition of loss, which can include damage assessment. This is something that I've always thought was sort of a weird phrasing in the case law because, it's like it makes it a crime, the fact that somebody investigated the crime. That seems a little bit weird. I had a different case a number of years ago. I think it was even back in like 2000 or something, where the guy had hacked into a lot of computers. And some of the computers, the people had just been like, oh, this computer's been hacked, and they just basically wiped it and reinstalled everything from backup, and it was fine. And that took them like, half an hour or something. So there wasn't requisite loss there. But some of the people did this deep dive forensic analysis and brought in these Air Force consultants, and they got paid $125 an hour or whatever it was. And for those computers, the damages were like $20,000. And to me, it always seemed weird to me that the difference between it being a crime and not being a crime was the fact that these guys restored from backup, not a crime, and these guys decided they really cared about who did it and what had happened and wanted to find out, and so that was a crime. Which seems like, it's sort of putting the definition in the hands of the victim, which is a little bit different than normal. Okay, so what about hacking or modifying your own phone? Surely you own this thing, so you can hack it. Well, we already talked about the problem with jailbreaking. Just wanted to raise a couple of other issues, including, for a lot of people, you get your phone from your employer. Okay, and so if you get your phone from your employer and it's not purely yours, you don't do the separation thing, then okay, you got to be careful because you have employment agreements, non-disclosure agreements, and other things that involve your use of the phone that may apply. I think one of the main things that employers worry about is that people will take work emails that should be on their phone and maybe should be segregated from personal stuff and either forward it to Gmail or something like that. So you need to be careful when manipulating data that's on a work phone in particular and doing something with it even though it's in your possession because you may be violating one of these agreements. I think trade secret misappropriation is actually one of the most interesting areas of the law because misappropriation is such a interesting concept. So the definition of trade secret is something that is valuable by virtue of not being known. and that the company or the owner of the trade secret has taken efforts to maintain the secrecy. And the number one kind of effort that companies take to maintain secrecy is NDAs, to put people under NDA and try to keep it confidential that way. And then misappropriation is breaching confidentiality, engaging in misconduct, or one of the things that's most interesting in the way that it clashes with the First Amendment is whether somebody knows or should have known that it was a trade secret status, and then uses the trade secret or publicizes the trade secret, regardless of whether they were involved in the initial misappropriation. So, you know, we're going to see those sorts of issues in the Bunner case, which involved redistribution of DCSS, which decrypted DVDs. And we see these trade secret misappropriation issues a lot with regards to newspapers. So if you represent newspapers, as sometimes I do, and somebody who is a source comes to the paper with some really interesting stuff, and that seems like maybe it's confidential, maybe it says trade secret or something on it, then the question is, can the newspaper use it? Can the newspaper report on it? Some of the biggest cases involving this issue are from the tobacco litigation. And you look at those, and there's like huge issues of trade secret, some with reporters, some with congressional staff, and those sorts of things having to do with trade secrets that were protected by the tobacco companies, and that they wanted to have maintained secret even after whistleblowers began to disclose them. Okay, what about listening to calls or reading SMS messages? So just your basic interception. Well, as we talked about before, interception of content is not allowed under the Wiretap Act. But one of the really complicated and interesting issues in the Wiretap Act is what an interception means. At what point is something intercepted? An interception is really not clearly defined in the law. It makes a lot of sense in the telephone context because, when you call, it's like, there it is, it's in real time, it's not stored anywhere. If you're not listening, it's gone, right? So that makes a lot of sense. If you're listening in, it's an interception. Otherwise, it's gone. But what about voicemail or packet-based communication where it's store and forward? And what about just email where it gets to your mailbox and then you read it or something and maybe you delete it, maybe you don't delete it, and the contents of that communication can be acquired at any point along the road when it's sort of in transmission. Because there's a separate law that involves stored communications, and the Wiretap Act is about intercepting communications in real time. So there's been some very interesting litigation on that issue of transmission. And what the case law basically agrees on is that when, let's say, an email, for example, is sort of going along, hopping happily along the internet from beginning point to end point, it's in transmission still, even though it's temporarily stored at a particular point before it's forwarded on. If you intercept it at the point of storage, it's storage incident to transmission, it's still in process. But what happens when it gets to the end point? What is the end point? So in the Councilman case, this involved a situation where, and I think it's interesting just to kind of go back to the facts of Councilman. I represented a co-defendant in that case, so it was really pretty interesting. The service provider in that case was a company that was sort of analyzing. It was a service for people who sold used books. And this was back right when Amazon was starting up. And the provider wanted to do some analysis on what books people were buying and selling. And so they had an email system, and then the emails would hit the system and then be distributed off into the various mailboxes for the people who had accounts on the system. And what the provider had done was collected the email content at the point that it hit the server prior to the point that it was sorted into people's individual mailboxes. And the question was, well, at that point on the server, was it in transmission or was it out of transmission and in storage? Why is this important? This is critically important. I know it sounds like, what's the difference? It's a privacy violation. Well, the critical importance is if it's still in transmission, you're not allowed to do it. Wiretap Act says no. If it's stored in its final storage place as a stored communication, service provider has full access, right? So that's fine, totally fine. So it's the difference between going to prison, not going to prison, is whether it was, on the server or sorted into the mailbox. And the Councilman case was sort of a complicated appellate procedure, but basically what the court decided was before it hits the final mailbox, it's still in transmission, which was a conclusion that I think was supported by a lot of privacy people, because otherwise you could just collect the email data at any point along the way, and Wiretap Act would never apply, and it wouldn't be protected. There wouldn't be any privacy there. But the question is, well, what happens when it gets to the end? And the court really left open that question of whether the term intercept means something could involve anything when it sort of crosses the finish line and it's in your mailbox or not. And there's another case in the Seventh Circuit that also sort of said, well, after something's hit the mailbox and you forward it on, that is an interception, because looking to the question of whether the recipient has opened and read, has really received the content yet or not. And it seems really arcane, but a lot rests on it for service providers and for the privacy of people who use these technologies to communicate. That's a big. So with SMS messages, it's a big question. Like where, at what point can you access these things? Can you access them at all? And even when they're stored, when they finally become stored, yes, there are some privacy protections, but they're much softer. The Stored Communications Act, which is part of the Electronic Communications Privacy Act, says you cannot access without authorization or exceed authorization to access a facility and then obtain access to a communication while it's in electronic storage in such system. Okay? So that protects, service providers can, but normal people can't. So the reason service providers can is because service providers can't exceed their authorization. The service provider provides the facility, they're authorized to access it. So there's other differences too that are very interesting and complicated. If you ever have an issue involving ECPA or the Stored Communications Act or anything, I urge you to talk to a lawyer who's knowledgeable in the area, because you wouldn't believe the stuff that's in the statute, like this question of electronic storage. Who here thinks they know what it means for a communication to be in electronic storage? Oh, you guys are smart. Stored electronically, right? How much harder could it be than that? Well, this is the statutory definition of electronic storage. Storage intermediate to transmission, or storage by the service for purposes of backup protection of such communication. So there's a huge debate going on about whether messages that have been opened and read are still stored under the Stored Communications Act. The difference is, if they're not stored, then the Stored Communications Act doesn't protect them. Doesn't protect them necessarily from outsiders, and doesn't protect them from the government accessing them. If they are in electronic storage, then they receive that protection. And there are a number of cases that have debated the question of what happens to post-receipt messages which are stored as normal people commonly think of storage. The Ninth Circuit, which is here in this part of the country, the Ninth Circuit has had two cases that have addressed this issue, both of which have found that post-receipt stored messages are still in electronic storage under the statute and thus protected from hackers and protected from warrantless government access. But there are cases in other parts of the country that have not gone this way, and the Department of Justice position is that the TFL case is wrong. That basically, once you've opened and read your messages, it's not protected. So, where does this leave us with SMS messages? SMS is like, sort of well, we'll talk about this in a minute, but the other question of, is SMS like a call, or is SMS like an email? Is it covered by CAN spam? Is it covered by the telephone consumer protection laws? This is just very difficult to figure out. Okay. As I said. So I've done a little bit of work in these areas. If you're talking about doing something with SMS Trojans or testing that kind of thing, oh my God, there's so many laws that could potentially apply to it. You have to be very careful. But I think that, you want to try to look carefully at the provisions of all the anti-Trojan, anti-commercial email type stuff, but the general appearance or the general rule, what courts seem to be following right now, is that SMS is more of a phone call than it is an email, and then it's covered by phone call type rules like the Telephone Consumer Protection Act as opposed to CAN spam. Now, the Telephone Consumer Protection Act, there's not a ton of litigation on it, but it can be very restrictive. It prohibits you from sending unsolicited commercial message to someone over a medium that generally they get charged for. So arguably, because people are generally charged for text messages, charged per text message, if you send an unsolicited commercial email to somebody over text, then you violated the Telephone Consumer Protection Act. And there are actually class actions pending right now against companies that provide group text messaging services. And basically the way this works is I want to have like a chat room over the phone with my friends. So I sign up all of you guys and we're all in this chat room and you've joined the group, legal fans, let's say, for all of the sort of fans of the law. And the service provider sends a message to all you guys and says, your friend Jennifer just added you to our great group text messaging thing. To find out more or to create your own groups, go to this link. And that is the act that the class actions claim violates the TCPA because it's a commercial message trying to get more clients for the business sent to people over text, which generally people have to pay for. So, you got to, whether it's security or you've got a new service idea or something like that, we've got to be very careful about all these laws and the way they interact. Yeah, there's a question over here.
Yeah, a few moments ago you told us that Skype and things like LTE fall under different rules because of packetized voice communication on a mobile device. But now you're saying that SMS, which follows the same packetized transmission on the network, is held as a phone call instead. Is there something that really differentiates those two, and why is the SMS being treated differently from voice over IP?
Yeah, it's a great question, and I'm not saying I think it is or it isn't. Like I know because there's a case or two that say that SMS is treated like a phone call, and the FCC has said that. Why would the FCC say that? Well, because the FCC has jurisdiction over that. So the more things that are considered phone call, happy for them because they get to be the ones who are in charge of it. And so we go along that way. But the reason why I said if you're going to be involved in any of these kinds of, sort of communications services, you have to be careful about CAN spam and which applies to email, is because I don't think that's a done deal. It's not obvious. So I'm just, I'm not a judge or anything, and I haven't seen any briefing on this, but I would guess, just say if I was going to think about it, I'd be like, well, Skype, that started on computers, and, but SMS started on phones, so SMS is like a phone call and Skype's like a computer thing, but it doesn't make any sense. I mean, it's not really all that principled of a distinction, right? You'd want to, if you were going to litigate it, you'd want to look at the underlying technology, you'd want to, sort of examine how it works, and then you'd want to compare it one way or the other to technologies where there's some case law on it or where there's some kind of like background about it to sort of say this is how the law should treat it. But it's just, there's not an answer. It's complicated. So I think you're right. What I said is contradictory, but I think that's because there's, it's because I have no idea. Yeah. Bob.
So specifically with the issue of SMS proteins, I've actually been wondering, back when there was one belt system, I know that the tariffs and some of the FCC regs have talked about network arms, and there was this list of stuff they didn't want you doing to hurt the network. I was just wondering if you could comment at all on what the current state of the world is with regard to mobile phones and that. Is it that the FCC regs effectively criminalize the act, or is it state law?
Mm-hmm. So the question is about, sort of the traditional, looking at network harm as something that the FCC is able to avoid or to protect against, and what's the kind of basis for the regulation of SMS type now? Like, what are they really looking to? And it's not state law; it is federal law, and it is under these kinds of privacy regulations that the FCC, like for the TCPA, the Telephone Consumer Protection Act, the FCC is empowered to enforce that and to issue regulations. So it's under their regulatory rulemaking authority that was passed as part of the federal statute that they look at the question of whether SMS messages should be included in the regulations they've already issued controlling commercial use of phone calls. So that's how that comes about. So, yeah. Okay, so another really fascinating, great issue involved with mobile, more so than your traditional laptop, is location tracking. Because these are devices that you tend to have with you all the time, they have information on them, or they generate information by which an outsider, either a person or the government, can track your physical location. And for those of you who are news of the world news junkies, you know that reporters for News of the World were paying Scotland Yard police officers to ping cell phones to get location information for various people of interest, not only the royal family but others. And so one of the questions is, well, is this okay? Is this data protected? What if you want to do a location-based service? What if you want to test it? What if you want to find out what kind of location-based information phones or other devices are leaking? How can you do that? So a couple of issues there I just want to highlight. The number one is that, you saw the slide before about the pen register trap and trace statute and how that regulates transactional information. And you might think that the information about how this interacts with the cell towers is transactional information because that is generally used in order to route the call information. So it's sort of like send it to this address or send it to this location. But I think, and it would be governed by pen trap, but I think one of the things to highlight and one of the reasons why this is so complicated for companies and other people who want to practice in this world is that sometimes transactional data is actually the content of the communication itself. So it's not just something that's used by the service provider to route the call, it is also something that I use in order to communicate with other people. Increasingly, as there's location-based services, that I say, I'm over here. This is how you can find me. This is where I am. And, all these applications now, Facebook wants to use your location, or I have this location-based, shopping service, or it's Foursquare, or whatever it is, where the transactional data that tells you your location is also the content of the communication. It's going to be governed by the Wiretap Act and by the Stored Communications Act. It's going to be governed by more stringent rules about what you can do with it, who can access it, what's required for consent, what service providers can do, and that sort of thing. So that's one thing that I would point out. And that makes a big difference in terms of law enforcement access as well, because law enforcement has an issue with they need a warrant to get content. They need less than that generally in order to get transactional information. So some other general issues about location tracking. You can also do location tracking with GPS, either GPS in the phone, or now, if you look online, they have all these GPS devices that you can they have ones for police where they can do a blow dart and blow it onto your car, and then your car has a GPS tracker on it, like when they're doing high-speed chases and stuff like that. They also have devices they can just put on your car and use GPS to track you that way. For private people, you have issues having to do with, even if you take out the Electronic Communications Privacy Act issues, you may have stalking issues or intrusion into seclusion issues or other kinds of things if you use location information, if you get access to it when you're not supposed to have it. There's a whole bunch of privacy torts that every state has a different formulation of them. So it's something to kind of be careful about where you don't have people's consent with location tracking. But one of the most interesting aspects, I think, is how the government uses location tracking or is increasingly using location tracking in order to find people and to do stuff. So a little bit about government access. So number one, the issue of cell phone triangulation. I mentioned this a little bit. There was a case that the AFF won involving cell phone tracking and the use of the tower data in order to pinpoint people, find out where they are. And in that case, the court ruled that a statute would allow law enforcement to get access to people's location information, yes, with less than a warrant, but that a court had the discretion to ask law enforcement to get a warrant and provide probable cause before they could force the telephone provider to turn over this kind of sensitive information. So this is really important for sort of court supervision of law enforcement access to this data, especially as cell phone data gets more and more precise. One of the things that the government argued in this case is that location data that's provided by cell tower triangulation is not all that precise, so it's not all that sensitive. Just gives police kind of the general realm of where people are. It's not that big of a deal. It's okay. But this, especially as technology evolves, it's going to get more and more precise. And this ruling allows the courts to be real supervisors and provide that check and balance they're supposed to provide on government access. In the GPS context, because it's not about electronic communications privacy, it's just a device that law enforcement can put on your car or something. There's actually a case before the Supreme Court this term, United States versus Jones, where the court is going to decide whether putting a GPS device on your car violates the Fourth Amendment or not. There are two cases. There's the Jones case, and here in the Ninth Circuit, there's Pineda-Moreno, which said, no, you don't have a Fourth Amendment protection because they took the DOJ's position. Individuals don't have any expectation of privacy in their movements on the public street because, of course, you could just be followed. And they used these cases from the 1970s where they put these beepers on drums of chemicals and then followed the drums of chemicals around to say that, it basically helped the cops because if they were, kind of going in the wrong direction, the beeping would get quieter and quieter and then they could turn around and go in the right way. They said, it's basically the same as in those cases. And there, if you're on the public streets, no expectation of privacy, but you can't use it to track people into private places. And in the Jones case, the underlying opinion, the court went the other way and said, look, this is nothing like those primitive beepers that we used to have. It's nothing like having a law enforcement guy, sort of trail you. This is pervasive, 24-hour a day, very precise kind of surveillance, and we think that the Fourth Amendment does apply. So the Supreme Court's going to decide that this term. It's an additional issue there about whether even installing the GPS device on the person's car, whether that violated the Fourth Amendment. I can't say I'm very hopeful about how Jones is going to turn out. So my advice to people who don't want to have law enforcement track their cars without a warrant or any probable cause would be to make sure that you keep your car locked up in your nice private garage on your estate and don't park your car in a public lot or on the street or anything like that. So it's a nice amount of privacy for rich people and for everybody else. You guys are in trouble. You're the ones the cops think are doing the crimes anyway. So tough for you. Yeah. Invasive?
Right, because it seems like I should have some level of privacy inside the cab of the car, at least. So, if they got to get inside, if they want to have a GPS.
So his question is, how do they do the installation? Is that invasive in any way? Because it seems like, if they had to do something like, open up the door and stick it in, maybe, inside, maybe you have a right to privacy there. If they have to do something where they hook it up to the battery of the car and they're draining some of the energy or using like even a drop of your gas or something like that to power it, like you could argue that or something. So yeah, cars aren't very well protected by the Fourth Amendment in the first place. And basically what these things are is they're just like little magnets. Like, those key holders that people have? You guys have this on the little underside of your bumper so that if I want to steal your car, I can just go take that out and do it? Well, it's just like that. It's just like a metal thing that sticks to the undercarriage. And so, there have been factual findings and arguments about how invasive it is. Does it scratch the car? Like looking to kind of enhance that aspect of it exactly because the Fourth Amendment tends to care about those kinds of things. But that's not going to be the facts in this case. It's going to be just pure placement on it. And I think that the argument will be that basically you're interfering with the owner's possessory interest in the car by converting the car to your own use as a police officer. And I don't know what the court's going to think about that. The court tends to protect property rights. This court tends to protect property rights even where they maybe don't protect privacy rights, which is why I said put your car on your property instead of, on the public street. And it is a question that was not presented in the lower case. It was not presented by the appellant from the lower court opinion that the Supreme Court added on as something it wanted the parties to brief. So clearly that issue is something the court's very interested in. I don't think the facts will be will make it that easy of a question to answer. So one thing to look at for GPS tracking is, if the Fourth Amendment won't save us, maybe legislation will. And there are statutes that are being proposed by lawmakers that would give people a right against law enforcement, require a warrant for technology to track physical location. So you might want to write a letter of support to your representative asking them to support this bill. A couple of just short other little points about mobile device search, because I don't think we can talk about government access or issues without talking about this. These things are really difficult when it comes to the Fourth Amendment for the Fourth Amendment to protect. You carry it across the border, it's subject to border search. And at the border, things can be searched without reasonable suspicion or any suspicion at all unless the search is really invasive. And the really invasive search cases are like, cavity searches, like strip searches and stuff like that. So, we argued that device searches were invasive like strip searches because of the intimacy and the quality of information that they could reveal, and courts have generally not gone for that. So if you bring something across the border and it's got information on it, it can be searched and seized by the border agents. What's the answer to that? Well, some people take like a dummy blank laptop with them when they go overseas and pull their data out of the cloud. The rules about law enforcement access to data that's that's not stored in the United States, that's extraterritorial and it's not so great. So, you kind of like are doing a little bit of, depending on what you're trying to protect, whether it's attorney-client privilege materials or trade secret documents or something like that, there's sort of a threat model about what you're trying to protect and, how to properly deploy encryption and that kind of thing. And I know that there have been some cases, some affirmative cases that people have tried to bring together on behalf of people who inherently deal with confidential information, like attorneys, about border crossing and government access to that information. Finally, search incident to arrest. This is an active issue that's also being litigated about whether when you get arrested, they can look at the data on your cell phone. Now, when you're arrested, they are allowed to do just basically a search of your person. They can do an inventory search of the stuff that you had on you. And the question is, when they do the search, can they just say, okay, well, she had a cell phone on her, or are they allowed to actually download what's on the cell phone or look at what's on the cell phone and look at that as well? And so, if you have a container on you, can they open the container? Is the phone like a container, or is it something else? All of this sort of analogies that lawyers try to use to help us come to an answer or understand better the challenges that modern technology poses to legal regulation. In the cases in this, there's some variation, but there was a new one in California really recently, which said that if you have a mobile phone on you at the time that you're arrested, the police can search it without a warrant, even if there's no danger of evidence destruction. Evidence destruction was one of the initial justifications for the search incident to arrest exception. They could search anything or get anything that was in your grab area so that you didn't, basically take and destroy evidence. Mostly, this was a rule that was invented in the day of flushing the stash down the toilet. And now it's a rule that's used to justify downloading the stuff on your iPhone and, looking at it later. So all very interesting issues that you want to think about when you're traveling with sensitive information on an iPad or iPhone or even your laptop, something like that. Yeah?
If there's a password lock on your phone, would they be allowed to use a tool that would bypass that with data, or do they have to have it unlocked, like a lockbox in your car? Do they have to?
Yeah. So the issue of if it's password protected in some way is super interesting. Lawyers love this. It's super interesting. So your question was, can they use a tool basically to break that lock or something? So the first thing I'll say, and probably lots of you guys already know this, but for people maybe who don't know, when you have like a password on your computer, on your laptop that lets you log in or something like that, that doesn't protect anything from the cops getting access to it. Okay, their forensic tools, the forensic tools that they use to do analysis, let's say for Windows machines, for example, of like Encase or whatever they're using, it doesn't obey or pay attention to various file permissions that are set up via account, right? It's not encrypted, it's not protected. They basically look at all the files that are on the hard drive and they don't discriminate They don't discriminate that way. And there's a couple of cases where, one in particular I'm thinking of, where the father gave permission to search the computer and the son had his own account on it that the father didn't have permission to search, but the police used a tool that basically looks at all the files and found child porn, and then, basically was that suppressible because the father could only give permission for some, or they looked beyond what, they were allowed to look? No, it was fine, right? So that's thing number one. Like, these aren't real protections from stopping them, and they have tools that don't necessarily obey it. Your question was, what if the code really does protect it in some way? Can they crack it, either because they're cracking encryption or something like that? So they can, if they have probable cause to search, they can break open containers, right? So if they have justification, if they're authorized and allowed to search it either through an exception or they have a warrant or something like that, they can break the containers. And they're allowed to break them to the extent, to search inside. So if they have a warrant for a rifle and you've got a big rifle-shaped box under your bed and there could be a rifle in there but it's got a big lock on it, they cut the lock off. Same thing, right? So then the follow-up question that people like to ask about this is, well, then can they force me to provide the decryption key if my stuff is encrypted or not? Or can I just say no? And that implicates Fifth Amendment rights. It's a complicated question. People feel differently about it. The EFF is actually in the process of litigating a case on that now. Marcia and Hanny have filed a brief on it, which you can go and read yourself. And courts are beginning to decide those issues. There have been a couple earlier cases that didn't really kind of address the issue head on, but courts are beginning to decide those issues. I'll just say the number one way that the government overcomes assertions of Fifth Amendment rights is they offer you some kind of immunity in exchange for the information that they want from you. And if they offer you the right kind of immunity, they can compel your cooperation afterwards. Because the Fifth Amendment kind of protects them from compelling information that can be used compelling you to be a witness against yourself. But if they promise not to use what you provide against you, then it's okay. So the question is, when you provide your decryption password, but the information's already there, are they compelling you to provide the underlying information, your diary or whatever, to them, or just compelling you to provide the password and they just promise not to use that? So, yeah. Oh, I have 5 minutes, or are you asking a question? Okay. So this is perfect timing because that's all that I was going to say. This is how you can reach me. So I'll take a couple questions if people have other questions about stuff. Yeah. They can't compel you to do anything to help them unless they grant you immunity. And the Fifth Amendment issue is, what do they have to grant you immunity for in order to compel your cooperation? That's the issue. So do people care about the Fifth Amendment stuff? Because I can really get into it a little bit more. That it has to, they can't compel a testimony, like you to give witness against yourself, or a testimonial act, that you do something that reveals something that's going to be used against you. So they can't use the fact that you provided the password against you, for sure. The question is, what about the other stuff? So if you keep a diary where you're like, I robbed those banks and it was awesome, and normally they can get that and they can use that against you, that's no problem. Now if you encrypt that, the question is, can they still get that information? Well, they may say, well, we want you to decrypt it, and you say, no, I have a Fifth Amendment right, and they say, well, just give us the password. We won't use the fact that you gave us the password against you. Can they then force you to disclose it then? That's the issue.
So you're saying that if you encrypt your entire hard drive, you can be potentially compelled to give the password, but if you have what you want to protect encrypted on the computer and you can't tell it as an encrypted file, you can't be compelled to tell them that it's an encrypted file.
Mm-hmm. So the question is, I think you're talking about stuff where there's like plausible deniability, like TrueCrypt, where you have a hidden encrypted partition or something like that, and it's like, they compel you to tell them something is encrypted on the hard drive? And the answer to that is, I guess, is kind of the same, which is no, they can't, unless they provide you with the right kind of immunity. So the question is, what's the scope of the immunity they could provide you to get you there? And then, of course, for you, if they really can't tell, you're just going to be like, I'm not saying yes. I don't care what kind of immunity they give me. That is one way to look at it. Was that subtle? I mean, there are more and less effective ways to hide stuff. And one of the things that is so powerful about that tool is that you may never find yourself in a position where somebody looks for your confidential documents because they may not even know they're on the hard drive and they may not know that there's anything encrypted there. So that helps you, not be in that position. You're not allowed to lie to cops. So that's a crime. You don't want to be in a position where you feel like you have to because your lawyer's going to tell you don't do it. So there's a question over here. If they don't know, they might not ask, right? But if they ask, you say, okay, so if you don't know, they might not ask. If they ask, or if they ask anything, you say, I want my lawyer. Don't say I want to remain silent, because that's not as good. Say, I want my lawyer, and then don't say anything else. And then when the lawyer comes, the lawyer can help you negotiate or deal with the Fifth Amendment issue, the Fifth Amendment stuff. But what the lawyer's going to say is, don't answer any questions. Then if the government wants to come back and offer you some kind of immunity, your lawyer can negotiate with them about the scope of immunity and what they'll be able to subsequently use against you afterwards. Like, pragmatically, that's the way that it should go. But the issue with the scope of immunity is complicated. And that's why you should really read Hanny and Marcia's brief, because it's interesting on that topic. Yes? Last question, because it's lunchtime, you guys.
Like a whole disk encryption and data destruction, though, the lost key in that key is gone.
It's gone.
How would they be able to help me or do anything in that way?
Help you find the key?
I've got my password, or if it was an actual key that got lost.
Well, if you're an American citizen, we don't do torture. So you got that going for you. For you non-American citizens, we got to be careful. So.
But the case that you're trying right now, I mean, typically you just say, forgot it. Well, she's got a password on her whole disk encryption.
You want to be, first of all, like I said, you can't lie to law enforcement. And so, but it's, if assuming, and we would, I could talk to you about how we deal with situations like that, but basically if you truly don't remember, there's not much they can do. Unless, if it's really interesting and you're like a terrorist, then they're going to put a lot of resources towards it and maybe they're going to try to crack it. But if it's just like they want to know my confidential communications with my clients, or I'm just a drug dealer or something like that, they're not going to care all that much. What they do is they have their ways, because there's other evidence. Like, they got to me for a reason, and they'll build up that evidence. And then they'll go to those people and they'll say, listen, we're going to give you a much lighter sentence if you rat Jennifer out. And since you're the one who sent her all that child porn or those incriminating emails anyway, why don't you just give us your versions of them and we can see what she answered back to you. So these things are all sort of important for protecting data, but you have to remember law enforcement has an immense amount of resources at their ability, and it's going to be like kind of a amalgamation or mosaic of information that they put together. So thanks everybody for coming, and thank you for your great questions.